Alright, Part 209, Railroad Safety Enforcement Procedures, Subpart A, General 209, Purpose of the 209, 3, Definition of 209, Service 5, Service 6, Request of the Administration, Subpart 7, the Subpoena Witness of the 8, Disposition, Formal Proceeding, 9, Filing, the Request for the Confidential Treatment, 11, 13, Consolidation, 15, Rules of Evidence, 17, Motion, Subpart B, Hazard Material Penalties, Civil Penalties generally, 101 to 103, Minimum, Maximum Penalties, 105, Know of the Probable Violation, 107, Repayment, Replied, 109, Repayment of the Penalty Compromise, 111, Informal, the Response to the Assessment, Requesting with a Hearing, 1115, 1117, Presiding Officer's Decision, 1119, 11.9, Assessment of Consideration, 121, Appeal, 131, Criminal Penalty, the Generally, 133, Referral Prosecution, Subpart C, Complying with the Order of 2009, 209, 201, Compliance Order, Generally, 202 and 203, with Notice of Investigation, 205, the Reply, 207, and consistent in the Order of the Hearing, 209, Hearing, the 211, Presiding Officer's Decision, 213, Appeal, 215, Time and Limitations. Alright, Subpart D, Disqualifying Procedure, 301, Preserve the Scope, 303, the Coverage, 305, Note of the Proposed Disqualification, 307, Reply, 309, Informal Response, 311, Request for the Hearing, 313, Discovery, 315, Subpoena, 317, Official Record, 319, Pre-Hearing, 321, Hearing, 323, Initial Decision, 325, Final Decision, 327, Appeal, 329, the Assessment Consideration, 331, Enforcement Disqualification Orders, 331, 333, Prohibition, 335, Penalty, 337, Information Collection. Subpart E, Reporting Remedial Application, the purpose of the 401, purpose of scope, 403, applicability, 405, Reporting Remedial Action, 407, Delayed Reports and Penalties. Subpart F, Enforcement Appealing Hearing Procedure for the Railing Rounding Decision pursuant to Title 49 CFR 172, 820, Title 209, 501, Review the Rail Transportation Service Security Route Analysis, Appendix A, Part 209, Statement of the Agency Policy Concerning with the Enforcement of the Federal Railroad Safety Law, with Appendix B, Part 209, Federal Railroad Administration Guideline for the Initial Hazard Material Assessment, Appendix C with the Part 209, Federal Railway Assessment, Federal Railroad Policy Statement concerning with small etnies. Alright, Subpart A, General, 209, Purpose. The Appendix A of this part contains the statement that the same agents and policy and enforcement of those laws, the parts describe the term and perceive them with the Federal Railroad Administration enforcement statute with the regulations related to the Railroad Safety Delegation, Secretary of the Transportation Administrator, the responsibility for enforcement, subchapter B with the chapter and C with the chapter subtitle B with the Title 49, which with the transportation ship with the hazardous materials railroad, Title 49, CFR 149. Exercise of the authority vested in the Secretary of Federal Road Safety Act of 1974, Title 45, U.S. Code 421, 431 through 441, amended with the Railroad Safety Improvement Act of 1988, Public Law 130.4342, June 20th, 1988, with the Title 49 CFR 149, and the exercise of the authority of the Secretary of Protecting the Railroad Safety further statute for transfer, Secretary, Section 6A of the Department of Transportation Act of Title 49, Appendix of the U.S. Standard Code 1655E, Title 49 CFR 149 CDE, F and G. Definitions is in this part. Administrative means the administrator of the FRA, deputy of the administrator of the FRA, delegated with either with the associated means of the associated administrator of the safety of the Federal Railroad Administrator of the person delegated with the designated the writing of the chief of counsel, mean with the chief of counsel for the FRA has or her delegated day with the means of the calendar day the Federal Hazardous Material Transportation Law in Title 49 U.S. Code 5011. Intent sequence of Federal Railroad Safety Law, meaning with the provisions of Law General of Title 49 U.S. Standard Code, Title 5 of the Part A of Title 49 U.S. Standard Code, Chapter 51 or 57, Safety, and the Rules, Regulation, Order, Standards issued with any part of these provisions. See the Public Law 103-272 for known for reconditioning of the statement. Statutory provisions contained with the Federal Following State for the Statute of the Federal Railroad Safety Act of 1970, Title 49 U.S. Standard Code 2101, 2117, 2011 7, 20, 131, 20 with 133 through 141, 143, 301, 302, 304, 311, 902, 905, the Section B11T and Public Law 103-272, formerly coded in Title 45 U.S. Standard Code 421, 431, intent sequence, the Hazardous Materials Transportation Act, the Hazmat Act, the Title 49 U.S. Standard Code 5101, intent sequence, formerly codified in Title 49, appendix of the U.S. Standard Code of the 1801, intent sequence of the Sanitary Food Transportation Act of 1990, the Title 49 U.S. Standard Code 5713, formerly codified in Title 49 U.S. Standard Code 2801, note, these laws transfer the jurisdiction Secretary of Transportation subsection E1 and 2 with the 6A with the Section 6 of the Department of Transportation Act Act effective June 1st, 1994. Title 49 U.S. Standard Code 2030-02 with 21-302, 2701 to 2703, 2305, 2502 to 2505, 2901, 2902, 805. 80504, formerly codified in Title 49 Appendix Code 1655E1 and 2 with a 6A with the Title 49 U.S. Standard Code 2011-1, 2011-09, formerly codified in Title 45 U.S. Standard Code 437 note with the 44-1E with the laws and transfer the doc as included are not limited to the following states for the safety applying for the Act of the Title 49 U.S. Standard Code 2011-0, 20-102, 2301, 2302, 2304, 2302, 2304. Formerly codified within Title 45 U.S. Standard Code 1 through 14 and 16 and 2 with the Locomotive Inspection Act of Title 49 U.S. Standard Code 2102, 2701 to 2703, 21302, 21304, formerly codified in Title 45 U.S. Standard Code 22384 within 3 Accident Reports Act of the Title U.S. Standard Code 2102, 2701, 2702, 2901, 2903, 21302, 21304, 2131, formerly codified in U.S. Standard Code 3843 and 4 the hours of service act of the Title 49 U.S. Standard Code 2102 with 2101, 2107, 21303, 21304, formerly codified in 45 U.S. Standard Code 6164, and B of the V's 5 of the Signal Inspection Act of the Title 49 U.S. Standard Code 2102, 2502, 2505, 2902, 21302, 21304, codified in 49 U.S. Standard Code 26. Or the FRA means the Federal Road Administration, U.S. Department of Transportation, Federal Safety, and Inspector means the FRA State Inspector, State Inspector Paris participated in the Road Safety Investigation Surveillance Activities under Part 212 of the Chapter any other official duly authorized for FRA motion that may require the presiding officer to take in the particular action. Person generally includes all the categories covered in Title 1 U.S. Standard Code, including but not limited to the following: railroad, any manager, supervisor, official, employee, agent of the railroad, owner of the manufacturer, lease, or less the railroad track of the facility, independent contractor providing goods or services through the railroad, any of the employees such as the owner, manufacturer, lease, or less, or independent contractor. However, the person would use the described name of the FRA alleges to have committed the violation provision law formally containing the Hazardous Material Transportation Act contained with the Hazardous Material Regulations, thus meaning the meaning of the Title 49 U.S. Standard Code 5012, with the formally codified with the 49 U.S. Standard Code U.S. 180211, an individual firm, co-partner of the Triple Cooperation Company Association, Joint Stock Association, including any trustee, receiver, their signer, or similar representative thereof of the government and Indian tribe authority, government the tribe when the hazardous material, the transportation, in common with the transportation hazardous material, further commercial enterprise, but such term does not include the United States Postal Service for the purpose of Title 49 U.S. Standard Code 523, 520, 551, 23, 51, 24, formerly contained in Section 110. 111 of the Hazardous Materials Transportation Act of the formerly codified in Title 49 U.S. Standard Code 1809, 1810 through 18. And the permanent agent for the instrumental of the federal government pleading in the means of the written submission of the same forth and claim for the allegation or argument of the evidence the presiding officer means any person authorized to preside over any of the hearing to make the decision of the record, including the administrative law and judge. Road means any form of non-highway grade transportation running by the rail's electronic magnetic guide, whether including community or other short-haul railroad passenger services, metropolitan service, and community railroad service, computer or operated with the Consolidated Corporate Railway Corporation, January 1st, 1979, high-speed ground transportation system with the connection of the metropolitan with the guard with the highway system with the new technology associated with the traditional railroads does not include the rapid transit operation in the urban area that are not. Connect with the general railroad system, the transportation railroad carrier, the means of the person with the providing of the railroad transportation, respondent means of the person upon the effort to serve with the notice of the probation, the violation, notice of the investigation, notice of the proposed disqualification. Alright, 209.5, the service of each of the order of notice for the other document required for the service owner to depart with the service of personally registered certified mail skip otherwise provided they earn service upon the personally duly authorized representative of the constituted service upon those requests. Service of registered certified mail completing upon the mail with the official United States Postal Service received with the registered certified mail, the certificate constituted with the prima of the face for the evidence for the service of request for the mission of the motion that may be made in the first class postage prepaid of each of the pleading must be accompanied with the certified service specifying how many of the when in the service was made. Alright, 2096, request of admission. Any party a party to any proceeding under the part PC, and with this part with the server of any of the party with the written with the request for the mission with the genuine or any of the relevant documents identified with the request for the truth of any of the relevant matters of the fact of application of the facts from forth in the request, if the matter of the within the mission of the request should be deemed admitted within 30 days of the receipt of the request of the party from the request the director of the party requesting the mission with the writing written answer on the day with the objection on the matter signed with the party the sworn and read answer should be specified specifically admitted denying the matter of the step forth in the detailed region, but the answering party cannot truthfully admit and deny the manner of the objection made, but the response thereof shall be stated in any manner admitted under the section conclusively established from the life of the presiding official the permit for the withdrawal of the amendment of the admission of the goods cause shown upon motion of the presiding officer may order with the party to respond to the request and admission. Or subpoena witness fee if the chief of the council may issue the subpoena of his or her own and issue the aim that matter related to the enforcement of railroad safety of the whether the proceeding on the subpart B and C of the D of the subpart of this part may have to be initiated on the presiding officer with the may issue the subpoena only with the written request of the party of the proceeding to make the adequate shown with the information solved with the material evidence of the proceeding. B. A subpoena may require the attendance of the witness for the disposition hearing with the production of the documentation and other tangible evidence for the possession control of the person of the both. The subpoena might be served with the person personally of any person not interested in person not less than 18 years of age or certified registered male. Or a service of the subpoena shall be made without delivering the copy of the subpoena with the appropriate demand with the step forth below the service of the subpoena required attendance for the person not complying with the online unless for the level delivery of the complete accorded by the tenor fee for the 1 day with attendance mileage as specified in the paragraph F of the section. However, the subpoena issued upon the request of the officer or agency of the United States the fee of the mileage and the time of the time service will be paid with the effort at the place of the time specified in the subpoena and attendance delivery of the copy of the subpoena may be made in the natural person handling it in the person. Leaving at his or her office with the person in charge thereof, leaving at his or her dwelling of the place on the below abode with some of the person suitable aid of the discretion of the residing therein, for the mailing of the registered of the certified mail to him and the his or her last known address. Any method whereby with the actual notice for the issue of content with the given of any of the fees for the made available prior to the return date, the intent with the author of the natural person by a hand copy of the subpoena of the registered agent services of any of the official office of the director, agent in the charge of any of the office of the person. Mailing the register of the certified mail of the representative of the list of the paragraph D2-1 with the section of his or her last known address, any method whereby actual notice for the given with such representative of the fees may be made available prior to the return date. The original subpoena bearing the certificate of the service of the failed within accordance with 2000 Statute 209(9). A witness subpoena with the FRS shall be entitled with the same fee if the mileage would be paid within witness the proceeding of the District Court of the United States to see the Title 28 U.S. Standard Code 1821, the witness for the mileage should be private with the personal requesting the subpoena to be issued within an appropriate case for the Chief Counsel of the hearing with the officer may direct the personal request of the issue of the subpoena with the production of the documentary other than the tangible evidence for the reimburse the responding person actual cost of the producing and they add the transportation with the evidence. Notwithstanding the provision of paragraph F of the section upon the request of the written fee of the witness fee of the mileage of the cost of producing the other evidence must be paid with the FRA with the office official if the subpoena determines that the basic good cause shown that the provision presence of subpoenaed witness evidence will be materially in advance of the proceeding and the party whose instance of the subpoena would be the suffer the serious and financial hardship that have been to the pay of the witness the fee of the mileage. Any person to whom the subpoena is directly made with the prior of the time of the specified with therein with combined with the number of the event with more than 10 days after the day of the service of such a subpoena apply with the written official who is issued the subpoena if the person is unable to receive the counsel to quash or modify the subpoena the application which shall contain the brief statement of the relief reasons relied upon the support of the action sought therein the issuing the official with the chief counsel in the case of the maybe the deny the application the quash the modifying the subpoena in case of the subpoena is produced the documentary other tangible evidence conditional denial with the application upon the advancement of the party of the behalf of the subpoena issue of the responsible cause of the providence producing evidence. If there is refusal to obey the subpoena served upon any person, the provision section of the FRA may request the Attorney General with the seek the aid of the United States District Court for any district of which the person found compelled the person that each for the notice to appear with the given the testimony to appear and produce the subpoena documents before the FRA both. Since of the FRA employed with engaged with the investigation gave it the right to the proceeding with the subpart B with the, or C with the part with proposing the electing faculty testimony may be assured of the filing request the Chief Counsel at least 15 days before the day of the inspection. Either the hearing request may be indicate the present intent of the requesting person will call if they employ the witness state with generally while the witness will be required. Alright, 2098, disposition formal proceeding. Any part of the proceeding on subpart B, C, D, and the subpart of the take of the testimony, any of the person, including the part in the disposition upon the oral examination in order for the proceeding of the officer following the granting with the motion under the paragraph B of the section of the description, the disposition may be taken in the form before any of the disinterested person with the authorized law and the administrative oath of the defendant's witness may be compelled with the subpoena provided in the statute 209 for the proceeding under the subpart D with the subpart 209.315. Alright, D, any part designed to take up the disposition witness shall file with the serve the written motion with set forth in the name of the witness for the date and time of the place the disposition subject matter of the witness expected testimony, whenever any part of the object for the taking of the disposition the region taken for the disposition, such motion will be granted only upon the showing of the good cause to exist for the taking of the position disposition, the information sought with the relevant subject matter involved with the proceeding, and the information is not obtainable from some other force or source that is movable, more convenient, less burdensome, less expensive. The request of unreasonable contemplative with unduly burdensome, unduly expensive, for taking into account with the need of the cause, limitation of the parties, or over the importance of the issue of the case, such a notice for the proceeding officer shall over the given of the taking into disposition, but it shall be not less than 10 days written notice unless the parties agree with the shorter period. D. Each witness testifying upon the condition shall be sworn to the adverse party shall have the right to cross examine the question, the propound the answer together together with all the objections that shall be reduced, the written subject of the witness, and the certified report of disposition taken out of the section may be due to discover the contradiction and impeach the testimony to point as a witness as evidence for the proceeding the permitted the paragraph F of the section within accordance with the limitation of the Fed R Civ PRO Pro 32 as though with applicable to these proceedings. Separately with the subject of the question, answer would know by the time they take up the disposition will be valid with witness personally presented with the testifying disposition may they offered in the evidence and imparting proceeding. 209 filing. Any materials after the FRA officer connected with the proceeding of the subpart B, C, D, and D, which shall be submitted to duplicate the Assistant Chief of the Council, Safety Officer for the Chief of the Council, Federal Administration, 12 New Jersey Avenue, Southeast Washington, D.C., 20590, with except for the documents produced in accordance with the subpoena that shall be represented with the place time specified by the subpoena. Or 20911, request for the confidential treatment. The section governs the proceeding with requesting the confidential treatment of the document filed with otherwise with FRA connection with the enforcement statute, the FRA regulation related safety for the purpose of the section enforcement should include the receipt of the documentation required of the submitted FRA regulations, all extensive investigative and compliance activities in addition with the development violation report, the recommendation for prosecution request the conditional confidential treatment of the respective document with the portion that they are made with on the basis of the information except for the mandatory disclosure of the requirements of the Freedom of Information Act, Title 5 U.S. Standard Code 552, required to be in the health and comment of the 18 U.S. Standard Code 1905, otherwise expect the law of public disclosure. Any document containing information for the confidential treatment that is required that it should be accompanied by the time of the filing statement that justifying the non-disclosure of referring to the specific legal authority claimed. Any document containing the information for the confidential treatment is requested that should be marked confidential contains confidential information within bold letters. And if confidential is requested, the entire document that is claimed. Non-confidential information for the document is not responsibly segregated with the confidential information accompanying the statement of the justification is shall indicate the confidential request as to the portion of the document that their performance person filing the document shall file together with the document. Second, a copy of the document for the information with which confidential treatment is requested be deleted if the person filing with the document which on the portion of the request to be competent does not submit the second copy of the document, the confidential information deleted by the FRA may assume that there is no objection to the public disclosure of the document entirely. Alright, E. FRA retains the right to make their own determination regarding any of the claims confidential. The decision of the FRA to deny the claim of the whole and in part with the opportunity for the respondent to given the person claim of the confidential information in the list in 5 days prior to the public disclosure. Alright, 20913 consolidation. Any time of the part the matter is set with the hearing under the subpart B, C, D, and B, C, and D, the authority chief of the council may consolidate with the matter with a similar matter of the pending with against the same respondent with any of the related matters pending against any others respondent upon the same part with the certification presiding officer consolidated proceeding on the unmanageable otherwise undesirable chief of the council with will sign and modify the consolidation. 2905 rules of evidence, federal rules of evidence for the United States Court Magistrates. Shall be employed with the general guidelines proceeding in subpart B, C, and D with this part. However, the relevant material evidence should be the evidence received in this record. 209-17, motions to be written and filed with the presiding officer, comply with the services of the parties in court with the 209-5, with the except of the oral motion that may be during the course of the hearing of the appearance of the pro before the presiding officer. Each motion shall state the particular order of the ruling, the action, and the desired ground thereof, and otherwise specify the presiding officer. Any other object of the written motion must be filed within 10 days after the receipt of the motion. Alright, hazardous material penalties, subpart B.